Good evening, friends. I am Manoj Kumar Chaudhary. Welcome you all on the behalf of Nani Palkiwala Law Club. Today we are at the part 2 of BNSS. In the first part, we have covered from the section 1 to section 132. Today we have our distinguished guest, Mr. Jayprakash Somani, Advocate, Supreme Court of India, to give us a comparative study of BNSS versus CrPC. Over to you, sir.
Thank you. Thank you, Manoj. And thank you, audience, for attending this webinar. We will complete today 264 sections, till 264 sections out of 531 sections of BNSS. So let me share you this screen first. This is comparative chart. We have completed till 132. Okay. Friends, this is a chapter 9 as per BNSS, and as per CrPC, chapter 8. So chapter 9, section 133 of BNSS, copy of order to accompany summons or warrant. Its earlier section in CrPC was 114. BNSS section 134, power to dispense with the personal attendance. Its earlier section was in CrPC section 115. In BNSS section 135, inquiry as to the truth of information. Its earlier section in CrPC 116. In BNSS section 136, order to give security. Its earlier section in CrPC section 117. In BNSS section 137, discharge of a person informed against. Its earlier section was in CrPC 118. BNSS section 138, commencement of a period for which security is required. Its earlier section was in CrPC section 119. BNSS section 139, contents of bond. Its earlier section was in CrPC 120. BNSS section 140, power to reject sureties. Its earlier section was in CrPC section 121. BNSS section 141, imprisonment in default of security. Its earlier section was in CrPC 122. In BNSS section 142, power to release persons in prison for failing to give security. Its earlier section was in CrPC 123. BNSS section 143, security for unexpired period of bond. Its earlier section was in CrPC section 124. Now friends, we are moving towards chapter 10 of BNSS, order for maintenance of wives and children and parent. Earlier chapter was in CrPC, chapter 9, order for maintenance of wife, children and parents. So remember that earlier section of maintenance was 125 in CrPC. Now in BNSS, section 144 is order for maintenance of wives, children, and parents. Its earlier section was in CrPC 125. BNSS section 145 procedure of maintenance. Then its earlier section was in CrPC 126. BNSS section 146 alteration in allowance. Its earlier section was in CrPC 127. BNSS section 147 enforcement of order of maintenance. Its earlier section was in CrPC 128. Chapter 11 maintenance of public order and tranquility. Its earlier chapter was 10 in CrPC, maintenance of public order and tranquility, that is unlawful assemblies. BNSS section 148 dispersal of assembly by use of civil force. Its earlier section was in CrPC 129. BNSS section 149 use of armed forces to disperse assembly. Its earlier section was in CrPC 130. BNSS section 150 power of certain armed force officers to disperse assembly. Its earlier section was in CrPC 131. In BNSS section 151 protection against prosecution for acts done under section 148, 149 and 150. Protection against prosecution for act done under section 148, 149 and 150. Its earlier section was in CrPC 132. Part B of the chapter 11. Public nuisance. BNSS section 152 conditional order for removal of nuisance. Its earlier section was in CrPC 133. BNSS section 153 service or notification of order. Its earlier section was in CrPC 134. BNSS section 154 persons to whom order is addressed to obey or show cause. Its earlier section was in CrPC 135. BNSS section 155 penalty for failure to comply with section 154. Its earlier section was in CrPC 136. BNSS section 156 procedure where existence of public right is denied. Its earlier section was in CrPC 137. BNSS section 157 procedure where person against whom order is made under section 152 appears to show cause. Its earlier section was in CrPC 138. BNSS section 158 power of magistrate to direct local investigation and examination of an expert. Its earlier section was in CrPC 139. BNSS section 159 power of magistrate to furnish written instruments, written instructions, etc. Its earlier section was in CrPC 140. BNSS section 160 procedure on order being made absolute and consequence of disobedience. Its earlier section was in CrPC 141. BNSS section 161 injunction pending injury. Its earlier section was in CrPC 142. BNSS section 162 magistrate may prohibit repetition or continuance of public nuisance. Its earlier section was in CrPC 143. Part C of that chapter, urgent cases of nuisance or apprehended danger. So 144 section like CRPC earlier. Now this section is in BNSS 163, power to issue order in urgent cases of nuisance or apprehended danger. Its earlier section was in CRPC 144. Now 144A of CRPC is now deleted in BNSS. Power to prohibit carrying arms in procession or mass drill or mass training with arms. That section was now deleted. Part D, dispute as to immovable property. Section in BNSS section 164, procedure where a dispute concerning land or water is likely to cause breach of peace. Its earlier section was in CRPC 145. BNSS section 165, power to attach subject of dispute or to appoint receiver. Its earlier section was in CRPC 146. BNSS section 166, dispute concerning right of use of land or water. Its earlier section was in CRPC 147. BNSS section 167, local inquiry. Its earlier section was in CRPC 148. Now we are in chapter 12, prevention action of the police. Preventive actions of the police. Its earlier chapter was in CRPC chapter 11, preventive action of the police. BNSS section 168, police to prevent cognizable offences. Its earlier section was in CRPC 149. BNSS section 169, information of design to commit cognizable offences. Its earlier section was in CRPC 150. BNSS section 170, arrest to prevent commission of cognizable offences. Its earlier section was in CRPC 151. BNSS section 171, prevention of injury to public property. Its earlier section was in CRPC 152. BNSS section 172 is new now. Persons bound to conform to lawful directions of police. And one section is deleted from BNSS, that is section 153 of CRPC, inspection of weight and measures. Chapter that covered in Weight and Measurement Act now, there in punishment section or in disciplinary process section, and a separate rule is framed there. So that part is deleted from here. Now chapter 13 of information to the police and their power to investigate. That is a FIR like that, 164 CRPC, FIR like that. So all these are in chapter 13 in BNSS, and earlier chapter was chapter 12, information to the police and their power to investigate. This is most important thing for prosecution lawyer as well as defense lawyer also. To see.
Viewpoint Ashok Jadhav, WhatsApp audio.
Just I will silence this. Yes. Okay. See, section BNSS section 173, information in cognizable cases. Now FIR section is 173 in BNSS. Earlier section was 154, information in cognizable cases. BNSS section 174, information as to non-cognizable cases and investigation of such cases. Its earlier section for non-cognizable cases was 155 in CRPC. BNSS section 175, police officers' power to investigate cognizable cases. Its earlier section was 156 in CrPC. 175 1, 175 2, 175 3, 175 4 from BNSS. 175 4 is a new subsection in BNSS. Its corresponding section was 156 1, 156 2, 156 3 was in CrPC. 156 4 was not there. That is new section in 175 of BNSS. 175 4 new subsection. BNSS section 176 procedure for investigation. Its earlier section was in CrPC 157. BNSS section 176 1, 176 2, 176 3 is a new subsection. 3 is new subsection. Earlier 2 was comparatively to CrPC 157 1, 157 2. BNSS section 177 report how submitted. Its earlier section was in CrPC 158. BNSS section 178 power to hold investigation or preliminary inquiry. Its earlier section was in CrPC 159. BNSS section 179 police officers power to require attendance of witnesses. Its earlier section was 160 in CrPC. Now examination of witnesses. 161 statement of before the statement given before police officer has no importance in the court of law like that. So this section is now in BNSS 180 examination of witnesses by police. But that is relevant also. That may be relevant, but that is not valid. That a particular police officer statement given before police officer, magistrate is not considering. But at some time they are taking the relevance of that while they are dictating judgment like that. Or for corroboration, they can consider that. So don't neglect that statements also while you are doing the legal practice. Section 161, earlier section was 161 of CrPC, examination of witnesses by police. In BNSS section 181, statements to police and use thereof. Its earlier section was 162 in CrPC. BNSS section 182, no inducement to be offered. Its earlier section was in CrPC 163. BNSS section 183, recording of confession and statement. Its earlier section was 164 in CrPC. That is statement before the magistrate. BNSS section 184, medical examination of victim of rape. Its earlier section was 164A in CrPC. BNSS section 185, search by police officer. Its earlier section was in CrPC 165. BNSS section 186, when office in charge of police station may require another to issue search warrant. Its earlier section was in CrPC 166. BNSS section 187, procedure when investigation cannot be completed in 24 hours. Its earlier section was in CrPC 167. BNSS section 188, report of investigation by subordinate of police officer. Its earlier section was 168 in CrPC. BNSS section 189, release of accused when evidence deficient. Its earlier section was in CrPC 169. BNSS section 190, cases to be sent to magistrate when evidence is sufficient. Its earlier section was in CrPC 170. BNSS section 191, complainant and witnesses not to be required to accompany police officer and not to be subject to restraint. Its earlier section was in CrPC 171. BNSS section 192, diary of proceedings in investigation. Its earlier section was in CrPC 172. BNSS section 193, report of police officer on completion of investigation. Its earlier section was in CrPC 173. BNSS section 194, police to inquire and report on suicide, etc. Its earlier section was in CrPC 174. BNSS section 195, power to summon persons. Its earlier section was in CrPC 175. BNSS section 196, inquiry by magistrate into cause of death. Its earlier section was in CrPC 176. Now we are moving to chapter 14 of BNSS and chapter 13 of CrPC. BNSS chapter 14, jurisdiction of the criminal courts in inquiries and trials. BNSS section 197, ordinary place of inquiry and trial. Its earlier section was in CrPC 177. BNSS section 198, place of inquiry or trial. Its earlier section was in CrPC 178. BNSS section 199, offense triable where act is done or consequence ensures. Its earlier section was in CrPC 179. BNSS section 200, place of trial where act is an offense by reason of relation to other offense. Its earlier section was in CrPC 180. BNSS section 201, place of trial in case of certain offenses. Its earlier section was in CrPC 181. BNSS section 202, offenses committed by means of electronic communications, letters, etc. Its earlier section was in CrPC 182. BNSS section 203, offenses committed on journey or voyage. Its earlier section was in CrPC 183. BNSS section 204, place of trial for offenses triable together. Its earlier section was in CrPC 184. BNSS section 205, power to order cases to be tried in different sessions, different sessions division. Its earlier section was in CrPC 185. BNSS section 206, High Court to decide in case of doubt district where inquiry or trial shall take place. Its earlier section was in CrPC 186. BNSS section 207, power to issue summons or warrant for offense committed beyond local jurisdiction. Its earlier section was in CrPC 187. BNSS section 208, offense committed outside India. Its earlier section was in CrPC 188. BNSS section 209, receipt of evidence relating to offenses committed outside India. Its earlier section was in CrPC 189. Now, chapter 15, conditions requisite for initiation of proceedings. Its earlier section, chapter was in CrPC 14, but now it is 15, chapter 15. Conditions requisite for initiation of proceedings. Initiation means to begin, to start, initiate. Section BNSS section 210, cognizance of offences by magistrate. Its earlier section was in CrPC 190. BNSS section 210, transfer on application of accused. Its earlier section was in CRPC 191. BNSS section 212, making over of cases to magistrate. Its earlier section was in CRPC 192. BNSS section 213, cognizance of offences by court of session. Its earlier section was in CRPC 193. BNSS section 214, additional session judges to try cases made over to them. Its earlier section was in CRPC 194. BNSS section 215, prosecution for contempt of lawful authority of public servant for offences against public justice and for offences related to the documents given in evidence. Its earlier section was in CRPC 195. BNSS section 216, procedure for witnesses in case of threatening, etc. Its earlier section was in CRPC 195A. BNSS section 217, prosecution for offences against state and for criminal conspiracy to commit such offence. Its earlier section was 196 in CRPC. BNSS section 218, prosecution of judges and public servants. Its corresponding section was in CRPC 197. BNSS section 219, prosecution for offences against marriage. Its earlier section was in CRPC 198. BNSS section 220, prosecution of offences under section 85 of Bharatiya Nyaya Sanhita 2023. Its earlier section was in CRPC 198A. BNSS section 221, cognizance of offence. Its earlier section was in CRPC 198B. BNSS section 222, prosecution for defamation. Its earlier section was in CRPC 199. Now, chapter 16, complaint to magistrates. Earlier chapter was 15, complaint to magistrate in CRPC. So direct we can file the complaint with magistrate when police officer is not ready to take the FIR to investigate like that. In that case, as per CRPC, we can file the matter in magistrate. So we have to take care of these sections for that purpose. Complaint to magistrates. In BNSS section 223, examination of complaints. Earlier section was in CRPC 200. In BNSS 223.1, 223.2 is new subsection. BNSS section 224, procedure by magistrate not competent to take cognizance of cases. Its earlier section was in CRPC 201. BNSS section 225, postponement of issues of process. Its earlier section was in CRPC 202. BNSS section 226, dismissal of complaint. Its earlier section was in CRPC 203. Now chapter 17, commencement of proceeding before magistrates. Its corresponding chapter was 16 in CRPC, commencement of proceedings before magistrate. In BNSS section 227, issue of process. Its earlier section was in CRPC 204. BNSS section 228, magistrate may dispense with personal attendance of accused. Its earlier section was in CRPC 205. BNSS section 229, special summons in cases of petty offences. Its earlier section was in CRPC 206. BNSS section 230, supply to accused a copy of police report and other documents. So earlier section was in CRPC 207. BNSS section 200, 231 supply of copies of statements and documents to accused in other cases triable by Court of Sessions. Its earlier section was in CRPC 208. BNSS section 232 commitment of case to Court of Session when offense is triable exclusively by it. Its earlier section was in CRPC 209. BNSS section 233 procedure to be followed when there is a complaint case and police investigation in respect of same offense. Its earlier section was 210. BNSS chapter 18. Chapter 17 is in CRPC. The charge is most important thing in criminal trial. BNSS section, the A part of this chapter 18 of BNSS, A part, form of charges. BNSS section 234 contains of charge. Its earlier section was in, just give me a few seconds to drink water. Its earlier section was in CRPC 211. BNSS section 235 particulars as to time, place and person. Its earlier section was in CRPC 212. BNSS section 236 when manner of committing offense must be stated. Its earlier section was in CRPC 213. BNSS section 237 what in charge taken in sense of law under which offense is punishable. Its earlier section was in CRPC 214. BNSS section 238 effect of errors. Its earlier section was in CRPC 215. BNSS section 239 court may alter charge. Its earlier section was in CRPC 216. BNSS section 240 recall of witnesses when charge altered. Its earlier section was 217 in CRPC. Now, chapter 18, part B, joinder of charges. BNSS section 241, separate charges for distinct offenses. Its earlier section was in CRPC 218. BNSS section 242, offenses of same kind within a year may be charged together. Earlier section was in CRPC 219. BNSS section 243, trial for more than one offense. Its earlier section was in CRPC 220. BNSS section 244, where it is doubtful what offense has been committed. Its earlier section was in CRPC 221. BNSS section 245, when offense proved included in offense charge. Its earlier section was in CRPC 222. BNSS section 246, what persons may be charged jointly. Its earlier section was in CRPC 223. BNSS section 247, withdrawal of remaining charges on conviction on one of the several charges. Its earlier section was in CRPC 224. Chapter 19. Trial before a court of session. Its earlier chapter was in CRPC chapter 18. Trial before the court of session. BNSS section 248, trial to be conducted by public prosecutor. Its earlier section was 225 in CRPC. BNSS section 249, opening case for prosecution. Its earlier section was in CRPC 226. BNSS section 250, discharge. 251. This is 251 is a new subsection. And 252(2) is there. Its corresponding section in CRPC of discharge is 227. When there is no evidence and prima facie, when session court feels that person should get discharged, then they can discharge here. Otherwise, if there is a substantial evidences, substantial charges, then framing of charges process they will carry on as given further. Section 251 of BNSS, framing of charges. Its earlier section was in CRPC 228. BNSS section 252, conviction on plea of guilty. Its earlier section was in CRPC 229. BNSS section 253, date for prosecution evidence. Its earlier section was in CRPC 230. BNSS section 254, evidence for prosecution. Its earlier section was in CRPC 231(1). Section BNSS section 254(1), 254(2) are new subsection. 254(3), its corresponding section was in CRPC 231(2). BNSS section 255 acquittal. Its corresponding section was in CRPC 232. BNSS section 256 entering upon defense. Its earlier section was in CRPC 233. BNSS section 257 arguments. Its earlier section was in CRPC 234. BNSS section 258, judgment of acquittal or conviction. Its earlier section was in CRPC 235. BNSS section 259, previous conviction. Its earlier section was in CRPC 236. BNSS section 264, procedure in cases instituted under subsection 2 of section 222. Now we are moving towards chapter 20, trial of warrant cases by magistrate. Its earlier chapter was 19. Now part A of this chapter 20 of BNSS. Section 261, compliance with section 230. Its earlier section was in CRPC 238. BNSS section 262, when accused shall be discharged. Section 262(1) is a new subsection in BNSS. Section 262(2), its corresponding section was in CRPC 239, related to when accused shall be discharged. BNSS section 263, framing of charges. Its corresponding section was in CRPC 240. BNSS section 264, conviction on plea of guilty. Its earlier section was in CRPC 241. BNSS section 265, evidence of prosecution. Its earlier section was in CRPC 242. BNSS section 266, evidence for defense. Its earlier section was 243. So we have to complete it till this 264 section, but we completed that A part till 266 sections of BNSS, comparing with CRPC 243 sections. So as usual, I will share you some thoughts related to practical tips of advocacy. So this is the first practical tips. From July onwards, whenever you are drafting some notices or drafting some plaint or drafting some complaints, so use both laws sections in complaint. Both as per IPC section so and so, as per BNSS section, BNS section so and so, in bracket IPC, sections. So judges are facing same problem which you are facing. Police officers are facing same problem which you are facing. So it is very easy for them to understand. So when you file the 171 petition, okay, maintenance petition, so write in bracket 125 in CrPC, BNSS section so and so in bracket. Old section, hide it in bracket for the better understanding of the magistrate, better understanding of the judges. So that improvement. When you are writing notice also to the parties, specifically in 138 cases, when you are writing the notices, when you are writing some sections of IPC, so don't write the section of IPC, write the section of BNS, and in bracket give the section of IPC also. So that will be a relevant and that will be a good. But gradually you develop the art of understanding both the section of BNSS versus CrPC, IPC versus BNS versus IPC, like that. So that this video will be very useful for you. Then another thing, I think we are taking these sessions now free of cost. So there is no bounding on the audience. So when to come, when to go, whether to attend sincerely or whether to not attend sincerely. So I think we should charge some fees, nominal fees, which anybody can easily pay. Say, suppose for full series, of part 1 to part 4, suppose we charge 50 rupees. So immediately a person who is interested, he will pay 50 rupees, his number will be added to send the Zoom link. And if anybody want to get the only one part, then he have to pay only 20 rupees and full series like that. So I think that will create some interest because they are paying fee. So they will join earlier. They will stay till end because some money will be there. 5 रुपए अभी बाकी है, ऐसे दिमाग में रहेगा, अरे क्यों जाना पहले, 5 रुपए बाकी है, 10 रुपए बाकी है, ऐसा थोड़ा सा कमेगा. But problem is that I have started this Nani Palkiwala National Law Club to share this information, whatever information, little information we have in last 36 years of our practice. So we should spread this free of cost. So this is our main motto. So main contention is we cannot charge it. And if we charge it, because unless and until we charge some fee, no importance for that particular section is there. But how we can charge it? We cannot charge it because this is not my commercial organization. Jayprakash Somani, advocate and solicitor. On behalf of that, my law firm, if I conducted some seminar, yes, I can charge. But when we are taking this webinar on the name of my guru, Nani Palkiwala National Law Club, so it is not good to charge the people and to earn money from the Nani Palkiwala Foundation. So main contention, my internal soul, Lord Krishna, my God, is not allowing me to take the money from this Nani Palkiwala National Law Club's activities. So we have to find out some balance, some ideas and practical, some balance we have to find out today. So this is in my mind, whenever in Nani Palkiwala we are charging some fees, so we should mention there, okay, these fees will go for the charity of those who are in need, or specifically charity for education purpose or distressed students like that. So, and we have the Nani Palkiwala National Law Club official group. So in official group, we will share that in this
session we collected this amount, and we donate this amount to this sanstha or to say. So not a single rupee I should earn from Nani Palkiwala National Law Club activity. But unless and until we charge some fees, not for all event we should charge fees, but some series, some information we charge some fee, not extravagant fee like 3,000, 5,000. Okay, no, only 20 rupees, 10 rupees, 50 rupees, so that a person who is paying 50 rupees, so seriously, he can attend the program. So that, and that 50 rupees we will straightway we will give the clear cut the figures in our official group. Okay, we got this amount in this Nani Palkiwala activity, and we have donated this amount to this. This transparency will be there, because I don't want to earn money from my guru's foundation. It should be a free of cost, but people are not getting. But if any law college request me, kindly allow free of cost access to my law student, then we will accept that. But it is the responsibility of that law college. Okay, maximum students should join from that law college. So this is my this thinking process. I am not on this concluding point whether I should charge or not charge, because that is confusion in my mind. That will I'm not comfortable to charge in Nani Palkiwala National Law Club activity. So I will think our convener, our other convener of other program. So we will sit together. We will decide whether to do this or not. And when we decide, then we will let you know about that. Last but not least, one more tip for advocacy. When you are arguing before any court, your face should be fresh, not in pressure. You should not be under pressure. Don't smile also. Don't keep smile faces. Because when you are arguing on behalf of accused, don't keep your smile face also. Smiling face you can keep in civil cases. When you are arguing civil cases, other cases. But when you are arguing cases from wife side, okay, and cases story is very sad story, that time you should not smile like that. So this is art. When you are standing before any court, trial court, then appellate court, then high court, then in our Supreme Court, when you are appearing before the court, your face should be fresh, without any pressure. Okay. And whatever you want, speak confidently. Speak confidently. Listen carefully what judges are telling. It is very hard to argue in my court. When you are starting admission hearing in my court, Supreme Court, they are not allowing you to speak at your own. When you are starting, just Lordship, the case is related to that, immediately they will cross you, because they are coming with proper study and proper notes of that case. And they don't have time to discuss the nonsense things when there is no material in the matter, and they are eager to dismiss that case. In that circumstances, which point is against you, you should properly study that. And which point is in favor of you, you should know that. So when you are aware which point is against you in that impugn order, specifically impugn order, which order we are challenging in the Supreme Court, maximum time we are challenging High Court's orders in Supreme Court, but in some statutory appeal we are challenging NCLT's order in Supreme Court, we are challenging AFT order in Supreme Court, we are challenging ITAT order in Supreme Court, which are challenging SEBI Tribunal's order in Supreme Court. So some statutory appeals are coming to Supreme Court from different statutory tribunal, like telephone tribunal. So many tribunals are there. So that order which you are challenging in Supreme Court, that is called impugn order. And in impugn order, which points are against you, you study it properly. So whenever they interrupt you on that point, your answer should be ready there. And if you are get little bit confused, they will dismiss the case. So a Supreme Court argument is the toughest arguments. Comparatively High Court and comparatively District Court, comparatively to Trial Court. Trial Court, you can enjoy your advocacy. You can start with your opening statement, then like that, or drama you can do that. Such type of drama here not allowed in Supreme Court, at least in admission case. After notice case, when registry process is completed and then when final arguments are there, that time then you will get chance a little bit to explain properly like that. But in administrative, so you are confident, your negative point properly you should study, your positive point you should properly press, and all you should done with proper fresh mood. Even though they dismiss your case, your face should not be get down. You should be pressed. Don't laugh also, but you should be pressed. Don't negative, positive, whatever effect, it should not be on you. Sthita pratya, as per the philosophy Gita, you should be sthita pratya. मैटर एडमिट होता है तो आनंद नहीं होना चाहिए, और मैटर डिसमिस होता है तो दुख भी होना नहीं चाहिए. बोलना बहुत आसान है, it is very easy to speak, but it is very hard to implement. Me also, I am speaking with you this, but me also, it is very hard to understand the negative points against us like that. And when matter get dismissed, so that time it is very hard to keep our face normal like that. So, but even though just you give here greatly obliged or deeply obliged or obliged, if matter is in your favor, deeply obliged, Lordship. If matter is dismissed, not in favor, even though you oblige, don't deeply oblige, but at least oblige. So sportly accept all these things. So this is the regular happenings in our court. You will find my separate courses for that on my app. How to argue in Supreme Court in SLP, criminal SLP, bail matter, how to argue in how to draft, and that courses is from drafting to argument. Not only argument, admission argument, no, but after notice argument, everything I have covered in that courses. So if you go to app, or if you contact to my PA, which number is given in the description, so she will send you the link and some information about that, and some discount for that courses also. So and that access for that courses, that recorded courses are there. Access for that courses is for 2 years. So it is best for the getting the mastery on the from drafting part to from argument to argument part. So nobody can teach you such type of things. Even though you are joining some chambers or you are joining juniorship, no senior can teach you that which I have prepared to teach you in our recorded courses. So that course also, if anybody want, they can get. They have the access, and in future we will arrange some question is there, some test also there, then certificate, automatic certificate on app. Then that process, we are in that process also. Okay, so this is from my side some tips, and after regular 2-3 days we will take the part 3, part 4, and in part 4 we will complete it. So these major 2 acts will complete it, and in next some Nani Palkiwala series, we'll take some jurisprudence series like that. Okay. Now I'm requesting Manoj to conclude this session. Manoj, now you can unmute yourself, Manoj.
Thank you, sir. Thank you for such an advisory tips. This is just like a sweet dish we got after the dinner. So important and so useful, and we can take it that in our practice. Thank you, participants. Thank you once again, everybody.
Thank you. Thank you all. Thank you.
नमस्कार, मैं पूजा राय आपको एडवोकेट जयप्रकाश सोमानी जी का थोड़ा सा परिचय करके देती हूँ। जयप्रकाश बंसीलाल सोमानी सर्वोच्च न्यायालय में अधिवक्ता हैं। 12 जूनियर के साथ वो लॉ फर्म चलाते हैं, जिसमें 5 AOR हैं। सोमानी जी भारत के हर राज्य और केंद्र शासित प्रदेश के मैटर बखूबी हैंडल करते हैं। सुप्रीम कोर्ट केस लॉ के ऊपर उनकी 61 किताबें प्रकाशित हुई हैं, जो Amazon और फ्लिपकार्ट पे अवेलेबल हैं। लिंक आपको नीचे डिस्क्रिप्शन में मिल जाएगा। भारत के लगभग सभी हाई कोर्ट और डिस्ट्रिक्ट कोर्ट के अधिवक्ता इन किताबों का उपयोग करते हैं। अगर आपको सोमानी जी की गाइडेंस अच्छी लगती है तो नीचे कमेंट बॉक्स में जरूर लिखें और अपने दोस्तों के साथ शेयर करना ना भूलें। हाँ, अगर आपने चैनल को सब्सक्राइब नहीं किया है तो सब्सक्राइब कर लें और बेल आइकन को दबाना ना भूलें, ताकि हमारा कोई भी नया वीडियो आता है उसका अपडेट आपको मिल सके। जय हिंद।